Maayong adlaw sa atong tanan ug welcome again sa atong panibagong serye na ihatod namo sa inyo karong adlaw. Sa among previous nga video, makita ninyo dito ang topic namo about Estate Tax Amnesty. And for this video, we will show you or we will discuss to you the procedure on how to apply for Estate Tax Amnesty. So there are 8 points you need to know on how to file Estate Tax Amnesty. The first one is, unsa ang form na gamiton nato in filing an Estate Tax Amnesty. Under the law, the form that should be used in filing Estate Tax Amnesty is the BIR Form number 2118-EA or ginatawag nato nga Estate Tax Amnesty Return. So in filing the Estate Tax Amnesty Return, it should be filed in 3 copies, meaning tulo ka copy ang imuhang i-file. The second point is, who shall file the Estate Tax Amnesty Return?
Ang mag-file dapat sa Estate Tax Amnesty Return is the executor, administrator, or authorized representative of the estates availing of the Estate Tax Amnesty. But in layman's term or in layman's point of view is dapat ang mag-file sa kaning Estate Tax Amnesty is katong mga heirs sa decedent nga namatay, katong mumana sa mga properties.
The third point is when and where to file and pay Estate Tax Amnesty Return.
Sa when or kung kanus-a dapat mag-file sa Estate Tax Amnesty Return, giingon diri is that it must be filed within 2 years from the effectivity of the implementing rules and regulations of the Estate Tax Amnesty under the Tax Amnesty Acts. Ang IRR sa Estate Tax Amnesty kay take effect siya around June of 2019. So 2 years from that, so naasa ang deadline sa pag-apply for Estate Tax Amnesty Return is until June of 2021. Sa kung asa naman i-file ang Estate Tax Amnesty Return, okay, i-file siya dapat sa Revenue District Office having jurisdiction over the last residence of the decedent at the time of his death. So kung asa nagpuyo ang decedent pagkamatay niya, dito nga Revenue District Office i-file ang Estate Tax Amnesty Return. Now, if the decedent is a non-resident, i-file naman siya sa Revenue District Office where the executor or administrator is registered. Or if dili registered ang executor or administrator, then at the legal residence of such executor or administrator. Now, if the decedent has no legal residence in the Philippines, the return shall be filed with the Revenue District Office number 39, South Quezon City.
For the payment of the Estate Tax Amnesty due, it should be paid using the Estate Tax Acceptance Payment Form or ginatawag nato nga BIR Form number 0621-EA to the authorized agent bank or revenue collection officer. So we will flash in this video that particular BIR form number for your reference. Now let's go to the fourth point. Tax rates and basis of tax. Now, ang tax rate nato for Estate Tax Amnesty is 6%, 6% siya. And that 6% is imposed on the decedent's net taxable estate determined at the time of death of the decedent, composed of all properties, real or personal, tangible or intangible, less allowable deduction. So again, ang tax rate is 6%. And kanang 6% is ang basis ana is the net taxable estate determined at the time of death, less allowable deduction. However, naatay minimum, no? Meaning to say, dili pwede mo ubos sa 5,000 pesos ang estate tax amnesty due. So, kung ang computation nimo based on the 6% is lesser than 5,000, then the amount due is 5,000 pesos. Let's go to the fifth point. How do we value estate for purposes of filing estate tax amnesty? Okay, under the law, the estate shall be valued at its fair market value as of the time of death. However, the value of real property as of the time of death shall be whichever is higher of, number 1, the zonal value as determined by the Commissioner of Internal Revenue, or the fair market value as shown in the schedule of values fixed by the provincial or city assessors. What does this mean? This means that yung value ng estate natin is depende kung ano yung valuation na nakasaad sa zonal value ng BIR at saka ano yung fair market value ng property na nakasaad sa schedule of value ng provincial or city assessors. So we will also provide you the link, no, for the zonal valuation na link for the zonal valuation provided by the BIR. And itong fair market value ng provincial or city assessor is makukuha ninyo ito sa province at saka sa city kung saan located ang property or ang estate. Okay, let's go to the 6th and 7th points. The 6th point is the gross estate, while the 7th point is the deduction. I will discuss these 2 points together. Di ba kaganina, nag-ingon ko na ang basis sa tax in computing the estate tax amnesty due is the net taxable estate. Now, before getting or arriving at the net taxable estate, it is important to know what is gross estate. So, gross estate includes all the property of the decedent at the time of death, real or personal, tangible or intangible, wherever situated, but excluding the exclusive properties of the surviving spouse. So, when you say gross estate, this refers sa kadtong mga properties sa decedent or sa taong nga namatay which are existing at the time of his death. Examples are, for example, na siya yuta nga na pagkamatay niya na siya yuta na bilin, or na siya mga personal properties like car or mga jewelries or mga any properties na nahibilin niya. Ang kaninga gross estate, minusan pa nato ni siya og deductions, no? Para mag-arrive ta to the net taxable estate. Now, what are the allowable deductions nga pwede nato i-minus sa gross estate? Example, sa mga examples sa allowable deduction. An example ana is family home, the value of the family home. No? So, under the law, naatay ka ng allowable deduction sa family home. Prior to the train law, ang allowable deduction for family home is 1 million pesos. So, kana siya, pwede nimo na siya i-deduct sa imuhang gross estate in order to arrive at the net taxable estate. Another example is the funeral expense, no? Before the effectivity of the train law, we have this funeral expense. Kay necessarily, pag naimamatay, mugasto man jud ka og para sa iyahang funeral. So, kana siya, pwede na siya maging allowed as deduction. So, I guess, nasabtan na ninyo no, unsa ang gross estate o unsa ang deduction. Again, these 2 points are important in arriving at the net taxable estate, which will be the basis for computing the estate tax amnesty due. Now, let's go to the 8th and last point. The attachment. So, unsa tong mga attachment na gina-require sa balaod para maka-apply ka for estate tax amnesty. Now, we have mandatory requirements. Okay? And kani nga mga requirements must be submitted with original copy and 2 photocopies of each document. So, isa ka original o duha ka photocopy. Number 1 is the certified true copy of the death certificate. So, since nagahisgot man ta diri taong namatay, so, isa sa mga mandatory requirements is ang death certificate. And dapat ka nga death certificate is a certified true copy. Number 2 is the taxpayer identification number of decedent and heirs. Number 3 is the Estate Tax Amnesty return. Number 4 is the Estate Tax Acceptance Payment Form. Katong gisgot na ako kaganina na kung magbayad ka og Estate Tax Amnesty due, bayaran mo siya gamit ning Estate Tax Acceptance Form. Number 5 is the Affidavit of Self-Adjudication or Deed of Extrajudicial Settlement of the Estate of the Decedent, or a court decision or judgment if the estate has been settled judicially or if there is a last will and testament. Number 6, certification of the barangay captain for the last residence of the decedent and claimed family home if any. So, makaya kag certification sa barangay captain na in that particular barangay ang last residence sa decedent. 7, for claims against the estate arising from the contract of loan. So, kung ang property sa decedent is kuan siya kanang naa siya yung mga claims or na subject siya into mortgage, then kailangan ang notarized promissory note. Notarized dapat. Number 8 is proof of the claimed property previously taxed, if any. Number 9 is proof of the claimed transfer for public use, if any. So, if the decedent has donated some of his properties for public use, then you can claim that as a deduction provided you furnish the BIR with proof. Number 10 is at least one valid government ID of the executor or administrator of the estate, or if there is no executor or administrator appointed, the heirs, transferees, beneficiaries, or authorized representative. So those are the mandatory requirements. Now let's go to the requirements if the properties left by the decedent are real properties. So again, these documents must be submitted with one original copy and 2 photocopies of each document. So ano yung mga requirements if ang estate is real properties? Number 1 is certified true copies of the transfer, original or condominium certificates of title of real property. So katong titulo sa property. So dapat na kay certified true copy. Number 2 is certified true copy of the tax declaration of real properties, including the improvements at the time of death or the succeeding available tax declaration issued nearest to the time of death, if any, if none is available at the time of death. So, aside from the certified true copy of the title, kailangan nimo og certified true copy sa tax declaration ana nga real property, including the tax declaration on the improvement. Kung na-building ba? Kung na-building, so naapon na corresponding tax declaration. Pero kung walay improvement ang property, you can just provide the BIR with a certificate of no improvement. No? Asa man nakuhaon? Dito sa assessor's office. Now, what if, for example, the properties left by the decedent are personal properties? So, unsa ang mga requirements kung personal properties? Number 1 is certificate of deposit, investment, or indebtedness owned by the decedent alone, are decedent and the surviving spouse or decedent jointly with others. Number 2 is certificate of registration of vehicles and other proof showing the correct value of the same. So kung nakaisakyanan or naisakyanan ng decedent, so katong certificate of registration sa sakyanan. Kung nai-stocks ang decedent, then certificate of stocks. We also provide proof of valuation of shares of stocks at the time of death and also proof of valuation of other types of personal property. Now, we also have other requirements, no, if applicable only. So again, the same rule applies. You will submit this with 1 original copy and 2 photocopies of each document. So, ano yung mga other requirements? Number 1 is, if the person transacting or processing the transfer is the authorized representative, so you will be required with duly notarized original special power of attorney or ginatawag nato nga SPA. So kung for example, mag-authorize lang mo person na mag-process sa inyong estate tax amnesty return, then kailangan na ay special power of attorney para kana nga person allowed siya mag-transact sa BIR. If the document is executed abroad, there must be a certification from the Philippine Consulate. So, ang document na gine-refer diri is the transaction document, katong affidavit of self-adjudication, or the deed of extrajudicial settlement. So, kung kaning affidavit of self-adjudication or deed of extrajudicial settlement was executed abroad, there should be a certification from the Philippine Consulate. As well as the special power of attorney. Kung gi-execute ni siya abroad, dapat naagiha po yung certification from the Philippine Consulate. Now, if the zonal value cannot be readily determined from the document submitted, then you may also be required to submit location plan or vicinity map, no, para ma-identify kung asa gyud located ang property for purposes of identifying the zonal value of that particular property. So, I guess that ends our discussion for the procedure in filing for estate tax amnesty return. Okay, that will be all for our series today. Thank you for watching and stay at home.